Hello and welcome to Topic 9, Lecture 1. And in this lecture, we're going to be talking about the Second Amendment, the right to bear arms. All right, so what are we going to be covering in this lecture? Well, first, we're going to take a look at the competing interpretations of the Second Amendment. There are two major ways that the Second Amendment is interpreted, so we'll take a look at those. And then we'll take a look at the two cases that are presented in this chapter. The cases are U.S. v. Miller and the District of Columbia versus Heller. That even though the right to bear arms is an incredibly important topic and it's a very hot political topic, there's not a lot of cases that have come to the Supreme Court in regards to the Second Amendment. And we'll talk about why that is in a moment. So that's what we've got on the docket. So let's get started. Okay, so before we get into the substance of the Second Amendment and the right to bear arms, I just want to make a clarification about how you spell the right to bear arms. And the reason I do this is I cannot tell you how many essays I've read on the right to bear arms wherein the word bear is spelled wrong. So remember, it's bear, not bear. So you have the right to keep and bear arms, B-E-A-R, not, you don't have the right to bear arms. So that person in that tank top is exercising their right to bear arms, B-A-R-E. So just make sure that when you're writing your essays on the right to bear arms, and also we have a discussion this week, make sure that you spell it correctly. Of course, you might support the right to arm bears. So it's not constitutionally protected though. But there's Paddington. I don't know if he really would need a gun or not. He's so dang cute. All right. So just wanted to bring that up since just so that you can be careful in terms of the way that you use the word B-E-A-R. All right. So here is the language of the Second Amendment. The Second Amendment is a very short amendment, as are many of the amendments. It says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So that's the language of the Second Amendment. So what's really interesting about the Second Amendment is that it's an odd amendment. And the reason that it's odd is that it's the only amendment that has like a preamble, okay? And we'll look at this, we'll identify where the preamble is in a moment. And it's because of this preamble that we have two different interpretations of the Second Amendment. Because there's a question in the Second Amendment, which clause is more important? In other words, which of these two clauses that we're going to take a look at in a moment, which is the one that drives the overall meaning of the Second Amendment? So let's go ahead and look at the Second Amendment again and look at this preamble clause and the other clause, and then we'll talk about how those two clauses are used very differently in terms of how to interpret the Second Amendment. So here's the Second Amendment again, and with highlights of the two different clauses. And so a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed, okay? And so there's two clauses here. One is known as the prefatory clause. And then in the previous slide, we're talking about, that the Second Amendment is weird because there's this like preface, right? It's like the clause, a well-regulated militia being necessary to the security of a free state. It's like, is that presenting the right to bear arms, or is it actually defining what the Second Amendment means? And so you have the prefatory clause in green, and then you have what's known as the operative clause, which is the right to bear arms clause. The right of the people to keep and bear arms shall not be infringed. And so because of these two different clauses, that the Second Amendment has been interpreted differently over time. Up until 2008 and the decision in the District of Columbia v. Heller, the Supreme Court, interpreted the Second Amendment according to the militia clause, the prefatory clause. They said that that's the clause that gives the Second Amendment meaning. But that all changed in the decision in DC versus Heller that basically said, no, it's not the prefatory clause that gives the Second Amendment meaning. It's the operative clause, the right to bear arms clause. And as I think most of us know, and you will know after this this chapter, and you will also know because there's a big part on the most dangerous branch, that it's the operative clause that is used to interpret the Second Amendment. And so now the Second Amendment is seen as a personal, individual right to bear arms. But let's look at the two different interpretations before moving forward. So some people interpret the Second Amendment as a collective right, basically saying that it is the militia clause, that the prefatory clause that is basically deriving and driving the meaning behind the Second Amendment. And for those who interpret the Second Amendment more as a collective or states' rights rather than an individual right, that, those folks are the ones who are basically gun control advocates. They're basically saying, yeah, the Second Amendment's in the Bill of Rights, but it's really about the state's ability to raise militias. It's not about an individual right to bear arms. And so, so they look at that militia clause, a well-regulated militia being necessary to the security of a free state shall not be infringed. That's how they interpret the Second Amendment. And the thinking behind this reasoning, the reasoning for why this is a collective right, a right of states, is they were thinking about, at the time of the addition of the Bill of Rights, like what were people concerned about? What were states concerned about? And what states were concerned about is the ability, the new ability that the federal government has in the Constitution that's ratified in 1788, their ability to raise armies, standing armies, permanent armies. That's a new power that's granted to the federal government. And there was a lot of fear of giving that kind of power to the national government. And so standing federal armies were really distrusted. And now we had this new constitution that gave Congress the ability to do just that. And so the Second Amendment is, again, this sort of prohibition. It's a thou shall not, right? It's telling the government that it can't do certain things. And the thing that it's telling the federal government that it can't do is it can't infringe upon the right to have a militia. And so, from their perspective, using the militia clause to drive the meaning, it's basically saying that this is about the rights of the states to arm civilians to serve in the militias. And that's what a militia is, to protect against a power grab from the federal armies. And so when you see that word militia, what a militia is basically the ability for a state to arm their citizens in order to not protect themselves individually, but arm their citizens of their state in order to participate in the militia. And that militia is necessary in case there's ever this, power grab by the federal government by the permanent standing armies that they can now create. And so from this perspective, they say that this isn't an individual right to bear arms, but a state's right to raise a citizen militia. And from this perspective, they basically say that the Second Amendment doesn't really have any relevance in the 21st century. The reason is because states no longer depend on civilians for defense, but that now we depend on the National Guard, which is a part of the federal standing army. Okay. And so they basically said this was necessary at this time period to make sure that there wasn't this power grab, this federal power grab against states. This gave states the ability to defend themselves, but states don't need militias, citizen militias, to defend themselves anymore because they depend on the National Guard when it comes to that kind of defense. So some people interpret the Second Amendment not as a collective or a state's right, but an individual right. And in doing this, they then focus on the bear arms clause that controls the meaning. That for them, from this perspective, that the Second Amendment's meaning is derived from the clause, the right of the people to keep and bear arms shall not be infringed. Thus, it's an individual right. And it goes without saying that this is the preferred interpretation of gun rights advocates, those who see the right to guns as an individual right, sort of like on par with the free individual right to freedom of expression to exercise one's religion. Now, from this perspective, they basically say, look, in the Second Amendment, it does use the word bear arms, and that the word arms is a military phrase. It means weapons for war. But they say that the word people implies that this is referring to individuals and not to states. And to support that, they look at two amendments, one that's in the Constitution, one that didn't make it into the Constitution fully. And the way that those amendments use the word people. So in the 10th Amendment, you'll remember that the 10th Amendment is basically the amendment that reserves powers to the states. And that the 10th Amendment says the power not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. So in the 10th Amendment, that they talk about states and people, indicating that people, that word indicates individual, not a collective. From this perspective, they also take a look at the Madison's Second Amendment. And in Madison's Second Amendment, it reads, the right of the people to keep and bear arms shall not be infringed, a well-armed and well-regulated militia being the best security of a free state, but no person religiously scrupulous of bearing arms shall be compelled to render military service in person. You know, there it's pretty clear that when you look at that language, that it seems as if that Second Amendment is indicating a right to an individual right to bear arms. However, that's not what ended up in the Bill of Rights. We've got to go with the text that's in the Bill of Rights. But that is one of the arguments that those who see the Second Amendment as an individual right point to. And so from these folks' perspective, they say that this is the right to bear arms is an inalienable individual right to self-defense. It's an inalienable individual right on par with the right to exercise your religion and the right to speak freely. And from this perspective, it's just as relevant today in the 21st century as it was in the 18th century. Okay, so now that we know about the two different ways that the Second Amendment is interpreted, let's go ahead and take a look at the Supreme Court and the cases that have come to the Supreme Court regarding the Second Amendment. Now, as you'll see from this case, the text, the chapter for this week, and as I've already mentioned in the lecture, that there have been very few Second Amendment cases that have come to the Supreme Court. U.S. v. Miller, which we'll take a look at in a moment, and then D.C. versus Heller. There is a Second Amendment case that was argued in front of the Supreme Court this term. We don't know what the decision is, but you'll want to pay attention to that as we get closer to the end of June, because we'll be getting a decision on that in this term. But there have been very few Second Amendment cases that have come to the Supreme Court. The question is why? I mean, it's such a hot topic now. Why don't we have this like rich case law as related to the Second Amendment? And the reason is that when it comes to gun control and gun control laws, that was a matter that was basically left to the states. It wasn't seen as the purview or the jurisdiction of the national government. And the reason for that is because of the 10th Amendment. And so the 10th Amendment is that amendment that reserves powers to the state. So it's basically saying, unless the federal government has been given this power or the state governments have been told they can't have this power, all the rest of the power is reserved to the states. And that's a lot of power. And it's oftentimes, that reserved power is oftentimes known as police power. I teach criminal justice, and one of the things we talk about is that the police power from the 10th Amendment is really the power that we give to the states to regulate our behavior and our morality. And so it's states who are basically telling us what kind of behavior we can engage in, and if we can't engage in that behavior, we criminalize it. And so it's really the states that are, have this sort of purview over the types of weapons you can own and any regulations that are around those. We also know that So for a long time, there weren't really any federal laws that were in place dealing with gun control. It was a power that was left to the states. And so it's not until that we actually see federal gun control laws come into play in the early part of the 20th century that the questions about whether or not those federal laws violate the Second Amendment come to the forefront. And also keep in mind incorporation, right? The Second Amendment was seen as applying only to the actions of the federal government. So the federal government has to, pass a gun control bill in order to trigger the Second Amendment. And it wasn't until actually District of Columbia versus Heller that the Second Amendment is actually incorporated to the states. So what's going on at the beginning of the 20th century that leads to the federal government passing a gun control law? Well, the reason for that is that we see an increase in crime in the early part of the 20th century. And there are two reasons for why we see this increase in crime. One has to do with the 18th Amendment and the Volstead Act. And basically what the 18th Amendment does is that it prohibits it's the Prohibition Amendment. And so it's the amendment that prohibits the production, transportation, and sale of alcohol. And that is brought into power, through the Volstead Act. And so suddenly in our Constitution, it prohibits, there's a prohibition on alcohol. And then the federal government is in charge with basically cracking down on people who are producing, transporting, and selling alcohol. And we know what happens when we prohibit things. It's not like people stop drinking the alcohol, right? When we prohibit things, the production, transportation, and sale of alcohol just goes underground. It goes into criminal enterprises. And so that because of the criminal enterprises that sort of develop around the bootleggers, that you see this rise of crime that is associated with people who are fighting over turfs, they're bootlegging turfs. We also see a rise in crime as we see an economic turmoil from the Great Depression. And, as I mentioned, there's this increase in organized crime as it relates to the prohibition of alcohol. Al Capone, famous gangsters that are sort of involved in the development of organized crime as it relates to prohibition. And so we see this rise of crime at this time period in the early parts of the 20th century, and there's pressure placed on the federal government, not just pressure, but federal government wants to do something about the rise of crime, in particular, the rise of the criminal activities of organized crime that stems forth from the prohibition. So what does the federal government do to address this rise in crime in the United States? Oh, well, one of the things they do is they say, look, we have organized crime. We also have economic crimes that are associated with bank robberies and things like that because of the economic crisis of the Great Depression. So one way that we can kind of reduce violent crime and the rise of crime is to place some controls on guns. And that's what the Congress does in 1934. They pass a National Firearms Act of 1934, which is basically a gun control measure. Now, it's not a general regulation of firearms. It's not really broad, like saying that you cannot own certain firearms throughout the whole of the United States. But it was because there was concern that given the Second Amendment, the sort of general regulation of firearms would be deemed as unconstitutional, sort of outside of the jurisdiction of the national government, because we've given that power to the states. They're the ones who are supposed to regulate firearms. And so instead, the National Firearms Act of 1934 is much more tailored and targeted. The focus of the Firearms Act is more limited in terms of the regulations, and that these regulations correspond with the taxing and interstate commerce powers of Congress. So just a little background there, that when the national government does want to get involved in criminal penalties, criminal law, right, when they want to create federal criminal code, they can only do that if they relate it to an enumerated power of Congress, right? So Congress has the power to tax, Congress has the power to regulate interstate commerce. And so if you have criminal activities that are going between state lines, that triggers Congress's power. And so that's what the National Firearms Act sort of focuses on, these powers that are granted to the federal government that allows them to regulate and control arms. And so since Congress has a taxing authority, they placed an excise tax on guns, and also that they said that there was going to be a gun registration for certain types of lethal weapons. And so that these really highly lethal weapons that was seen to derive from the national government's power to keep peace and domestic tranquility. And so guns such as machine guns, short barrel firearms, sawed-off shotguns, those were all prohibited by this. Also, what was prohibited was that there was a ban on transporting these kinds of guns between state lines, okay, or through the mail, okay, because the federal government has control over interstate commerce and the Postal Service, and so therefore they can ban certain things that they think are jeopardizing the safety of Americans. And so it was against the law to transport a sawed-off shotgun between state lines or to use the Postal Service to transport those weapons. And so that sort of gives you a little bit of background on the National Firearms Act, which is important to know because that is the law that is called into question. The constitutionality of this law is called into question in the case that we're going to look at next. Okay, so let's talk about the facts of the case of the regarding the first case the Supreme Court hears on the Second Amendment. And that case is U.S. v. Miller in 1939. So let's talk a little bit about the facts of the case. So this case is about some bank robbers. And one of them is Jack Miller, who's pictured in the, just above me there, and his friend Frank Layton. And Jack Miller was a longtime bank robber. He was from Oklahoma. He had a really flamboyant personality. In preparation for the lecture, I was looking at some old news stories about Jack Miller, and supposedly he was like this renowned sort of drunk, dressed real nice, real flamboyant, and he loved his weapons. He totally loved his sawed-off shotgun. And you've probably heard about a lot of other gangsters, You've heard about Bonnie and Clyde, Pretty Boy Floyd, Machine Gun Kelly, not the one we know today, but from the past, it was on the top FBI list of robbers. But you probably haven't heard about Jack Miller. But he was just as notorious at that time as well. And why we know about Jack Miller today is because obviously he is the one who is named in this famous case. So what did Jack Miller and his buddy Frank Layton do? Well, what they did was they owned weapons that were prohibited by the Firearms Control Act of 1934. Jack Miller had, as I stated, a sawed-off shotgun, and as robbers will do, he was in a vehicle with his sawed-off shotgun, and he went between Oklahoma and Arkansas. And because the cops sort of were onto him, knew he was a bank robber, they pulled him over, and they found this sawed-off shotgun in his car. And that was a violation of the Firearms Control Act. He had also not paid taxes on it. He also had not registered the gun. So he was, charged and convicted of violating this federal gun control act. And him and his team cried foul. They basically said that federal law violated the individual right to bear arms that is outlined in the Second Amendment. So let's take a look at the question that was before the court. Okay, so what was the question before the court in U.S. v. Miller? The question was, does the National Firearms Act violate the Second Amendment of the Constitution? And in an 8-0 decision, that the court said no, that the National Firearms Act does not violate the Second Amendment. Why? What was their reasoning? Basically, they said that owning or using a sawed-off shotgun is not related to the preservation of a well-regulated militia. And so that basically they're saying that the Second Amendment is about arming people in order to participate in a citizen's militia to defend the state. And they basically said that this sort of a sawed-off shotgun is not an ordinary military weapon. And as such, we cannot say that the Second Amendment allows for the ownership of this sort of gun. So, this ruling is sort of limited in a way. I mean, it's important because it does say that the Second Amendment is about raising a militia for a collective right for the states to, arm people for a militia. However, others say, well, this is still about an individual right to bear arms because individuals have to be able to bear arms in order to staff a militia. And also they're basically saying that you can bear arms individually, just can't bear certain kinds of arms, non-military sorts of arms. So you can't bear a sawed-off shotgun, right? However, that doesn't mean that individuals couldn't own other types of guns that could be used in a militia capacity. Okay, so it does use sort of a collective interpretation of the Second Amendment, but it doesn't completely take the individual out of the equation in terms of understanding the Second Amendment. So the collective rights interpretation of the Second Amendment was the precedent for 70 years in the United States. The Supreme Court, broadly defined the Second Amendment as an amendment having to do with the state's rights ability to raise a militia. And that was what was in force for about 70 years. This all comes to an end in the landmark case, District of Columbia versus Heller in 2008. And in that case, as you're going to find out, Louis, quiet, please. In that case, the court rules that the Second Amendment is an individual right to bear arms. And that's where we are today. But also, like with all rights, that there are limits on the right to bear arms. And Justice Scalia, who writes the opinion in the case, is very clear about that. And that's basically what the future of the Second Amendment cases before the Supreme Court are going to be about whether or not, to what extent that limitations can be placed on the right to bear arms. Now, look, I'm going to let you read the case yourself. It's a famous case. I know that a lot of you are interested either both in the individual right to bear arms or seeing the individual right to bear arms is potentially a negative thing. And so I expect that you'll read the case. It's an easy case to read. It has to do with, a provision in the District of Columbia that makes it ginormously difficult for anybody to own a handgun, to have a handgun. It has to be registered. It has to go through like an approval process, and very few people are actually given that right or that permission. And that's what's challenged in DC versus Heller. Also, you'll be reading a lot about it in the Most Dangerous Branch as well. And then finally, I'm going to leave it to you to read the case because it's a part of your assignment this week on the background for the online discussion this week. So enjoy reading the DC versus Heller. You can definitely do a case brief on that if you are so inclined. Thanks a lot for paying attention. My little cutie boy, Theo, says hello. He's making a guest appearance here today. And so that's it for the Second Amendment. The next lecture is about the introduction to the right to privacy. So thanks for your attention. I appreciate it, and I'll talk to you again soon.